Hi, Assalamualaikum. My name is Nurdini Assyifaa binti Syed Sukri and my teammate.
My name is Nadirah binti Mohamad Saufi.
So, our assignment task in commercial law, we have been ordered to present these two subtopics, which is discharge and remedies. So, without wasting the time, we go to discharge. What is discharge? Discharge of contract happens when the parties of the contract are released from any obligation arises under the contract. In other words, parties to the contract are no longer obliged to do as agreed under the contract. Contract can be released in four types, which are by performance, by agreement, by breach of contract, and by frustration. Performance is the most common way to discharge a contract. A contract is said to be discharged when the party to the contract has performed what they have agreed to do in the contract. In case in Carter versus Powell, plaintiff claim of remuneration was rejected by court. Plaintiff passed away 2 weeks before the voyage ended. In order to discharge a contract, the performance of an obligation must be done strictly in accordance with the term of the contract unless otherwise agreed. This is evident from the provision of Section 14 Contract Act 1950, which provides that a contract must be performed in its entirety unless otherwise agreed by the parties. The parties to a contract must be prepared to perform their respective obligation at the time and place stipulated in the contract. First, time of performance. Second, place performance. Third, reciprocal promises. Next, contingent contract.
Next, tender performance, seats, personal agreement, and lastly, joint agreement. Time of performance. The parties to a contract may also stipulate the time of performance is an essence of the contract. Section 56 provides that any delay in the performance would entitle the innocent parties either to terminate or continue with the contract. If a contract provides for the time of performance but does not make it an essence of the contract does not become voidable for a failure to abide by such time. The innocent party may, however, claim compensation for loss suffered as a result thereof. Section 56(2). Section 56(3) is only applicable when the contract was performed between parties outside the stipulated time, not when it had not been performed at all. Place of performance. Section 50 provides that when the place for performance had not been determined by a contract, then it would be the duty of the promisor to ask the promisee where he would want the contract to be performed if the performance is to be effected without the promise application. Reciprocal promise in executory contracts. Under Section 52, the related case is Central Malaysia Development Ltd versus Chin Pak Chin. The defendant, under an agreement, was to execute a valid transfer and deliver vacant possession of a piece of land to the plaintiff upon the latter paying the agreed deposit. Section 54 provides that where one party prevents the other from performing his promise under contract, the contract is voidable at option of the party so prevented. Contingent contracts. These are contracts to do or not to do something depending on some event. Collateral to the contract does or does not happen. Section 32. A contingent contract cannot be enforced until the happening of an event stipulated in the contract if contract is contingent upon the happening of a future uncertain event. Section 33. However, if a contract is contingent upon an uncertain event not happening, it can be enforced when the event becomes impossible. Section 34. If a contract is contingent on the performance of an act by a person in a future unspecified time, the event shall be considered to become impossible when such person has done something to make the happening of the event impossible. Section 35. Tender of performance. Section 39(2). It was unconditional. It must be made under the circumstances. It was made at proper time and place. The promise must have reasonable opportunity. Personal performance, whether or not the parties to a contract are required to personally perform their respective obligation depends on their intentions at the time the contract was made. Section 41. Where personal performance is not implied, a promiser may employ a competent third party to perform his obligation but he still remains personally liable. Joint agreements, where two or more persons have made a promise to be promised under a contract. They are said to be jointly and severally liable under the contract. There are four sections: Section 44.1, 44.2, 44.3, and 45. Discharge by agreement, when parties to the contract agree under free consent to discharge obligation from the former contract. A contract can be discharged if the parties agrees or consent that the contract will be discharged. The agreement can be made during the contract or after the contract have been made. Application under Section 63, if the parties to a contract agree to substitute a new contract for its novation, the original contract need to be performed. Section 63 provides that the parties can agree either substitute an existing contract with a new one or rescind the original contract or alter the original contract. A novation is the substitution of the existing contract with a new one. The consideration for this new contract is the mutual discharge of the original price. Under Section 64, every promise may dispense with or remit wholly or in part the performance of the promise made to him, or may extend the time for such performance, or may accept instead of it any satisfaction with which he thinks fit. Application of the dispensation or remission of performance provided under Section 64 above can be seen under the following situation: the payment of a lesser sum to satisfy the whole debt, payment of a lesser sum by a third party to satisfy a larger debt, payment in satisfaction of an unascertained sum, an arrangement for the settlement of debts between a debtor and his creditors.
Discharge by breach. Under Section 40, when one party to a contract is in breach of contract, the other party to the contract has right to rescind the contract and claim damage the breach. Section 40 of the Contract Act, when a party to a contract has refused to perform or disable himself from performing his promise in its entirety, the promise may put an end of the contract. A breach may occur because of two ways. First, refusal perform, where one party informs the other by conduct or words that he does not want to go on with the contract. The former party is said to repudiate the contract. Second, disability to perform. If one of the parties is disabled to perform, the contract is discharged. If the disability is because of something beyond the control of the parties, then it does not amount to a breach of contract, but it discharged through frustration. A breach can either be an anticipatory breach or an actual breach. Anticipatory breach occur where one party indicates before the time of the performance due either that does not intend to perform, that he intends performance different from that set out in the contract. The innocent party can repudiate their contractual obligation as soon as the other party indicates their refusal to perform and wait to the performance date and hope that the party perform their duties.
Discharge by frustration. A contract is terminated if the things that the parties agreed to do is impossible to perform. It can be at the time the contract was made or when the contract has been made the obligation becomes impossible to perform. Section 57.2. a contract the performance of which had become impossible or unlawful after it was made due to some event the promiser could not prevent. The contract is said to have been frustrated, the doctrine of frustration, and become void. To be frustrated, the following qualifications must be satisfied. Section 57(2) of the Contract Act. The supervening event must be something that the promiser could not prevent. A frustrating event which was self-induced and caused by a default of a party will not discharge the party from the contract. The performance of the contract must have been impossible and not merely more difficult or more expensive. Also, the event that occurred had caused a fundamental or radical change in the circumstances so as to make the performance of the contract something radically different from that originally undertaken. The frustrating event has substantially prevented the performance of the contract is a wound.
So we move to remedies. What is remedies? Remedy is general term which means a right that can be claimed by a party to a contract that experienced losses because of the other party to the contract was breached. 4 types of remedies. First, damage, specific performance, injunction, and quantum merit. Damages given to a person in a contract who does not receive the rights that he should from the contract. The aim of damages is to reward losers and damage because of the other party's breach. Damages might be of specific or unspecific amounts. It depends to the terms agreed. Damages of specific amount are damaged by which the amount has already been agreed upon if there is a breach. It has been agreed when the contract is being made. Damages of unspecific amount are divided into 3. First, substantial. A reward given is to put plaintiff in a place that he should if defendant perform the contractual obligation. Second, nominal. A small reward to plaintiff after he shows that there is a breach of contract even though there is no real losses incurred. Lastly, third, exemplary. A reward given is far higher than the losses incurred. Specific performance. It is an order by court to parties to a contract to perform as contracted. Under Specific Relief Act 1950, a court gives this order in a situation if the contractual obligation is a trust, actual damage cannot be ascertained, or a breach cannot be adequately relieved by compensation of money. Injunction. Injunction is discretionary given by court under Section 50, Specific Relief Act 1950. An injunction may be of mandatory or interlocutory. The remedy of an interlocutory injunction is used by a party to maintain status quo of a subject matter in Appendix 3. A permanent mandatory injunction is a court order requiring something to be done. An injunction can also be in a form of restraining order or stopping something from being done. Quantum merit. A claim that can be made by plaintiff who has performed obligation under a contract and then choose to rescind the contract after defendant's breach. Court will order a value that is